My manager filed a lawsuit against me while I was still on maternity leave, sitting in a nursing chair at 2 a.m, and I want to tell you what happened when his own assistant walked into that tribunal room and sat down. That witness statement is the centre of everything. I'm going to tell you exactly what was in it, but the statement only means what it means if you understand what the 8 months before it cost me, professionally, financially, and in ways that do not have a clean category. So let me be precise, because precision is the only register I have left for this story. My name is Rachel. I am 34 years old. Before all of this, I was a senior financial analyst at a corporate services firm in London. 8 years into a career I had built methodically and with considerable effort, earning £62,000 a year, managing a team of 4 and operating with the specific confidence of someone who has earned their position and knows it. I took maternity leave in March. My daughter's name is Isla. She was born on the 14th and was, from the first moment, the most competent person in any room she occupied. I discovered the irregularity 6 weeks into maternity leave. Not because I was looking, because a former colleague forwarded me a document chain by mistake, an internal analysis that had been misdirected to my personal email, which was still listed on a distribution group that had not been updated before my leave. I read it. I am an analyst. Reading financial documents is what I do with the instinctive attention that other people give to whether the weather has changed. The document contained figures that did not reconcile with the consolidated accounts I had reviewed before leaving. The discrepancy was not small. It was £273,000, distributed across 4 client accounts over a 7-month period in a pattern that had the specific shape of deliberate concealment rather than error. The manager responsible for those accounts was a man named Christopher. He had been with the company for 16 years, was a director, and was, by general understanding within the firm, someone whose position was protected by a combination of seniority, personal relationships with board members, and the kind of institutional memory that makes people uncomfortable about challenging those who hold it. He was not, in the conventional sense, untouchable, but he had spent 16 years making himself feel that way to the people around him. I want to give you his dimension, because he is not simply a function of corruption. Christopher had built something real, 16 years of client relationships, of deals structured and delivered, of a practice area that genuinely performed. He was good at his job in the ways that mattered to the firm's revenue line. What he had also built, alongside the legitimate practice, was a smaller and quieter mechanism for managing his own exposure, routing certain fees, smoothing certain timelines, adjusting certain figures in ways that he had perhaps told himself were the kind of accommodations that complex financial services work requires. He had been doing it long enough that it had stopped feeling like a decision and started feeling like a system. That is how these things survive, not through malice at every moment, but through normalization over time. I filed a protected disclosure under the Public Interest Disclosure Act 1998 in writing to the firm's compliance function and, simultaneously, to the Financial Conduct Authority. I did this from my nursing chair at 11:43 on a Tuesday evening in April, with Isla asleep against my shoulder and the document chain open on my laptop. I did it methodically and I did it completely, and I forwarded copies of everything to my personal email before I closed the laptop, because I have worked in financial services long enough to know what happens to documents when a disclosure becomes inconvenient. I then put Isla in her crib and went to sleep for 4 hours, which is the quantity of sleep available to the mother of a 6-week-old, and which I have never in my life appreciated more than I did that night. Now I want to stop, because I need you to feel the specific shape of what I am about to describe. I have just told you about a woman on maternity leave, feeding her infant in the middle of the night, who identified a £273,000 irregularity and reported it to the regulator by midnight. And I want you to hold that image, the nursing chair, the laptop, the sleeping baby, the compliance email, and then I want you to hear what Christopher did next, because it is the thing that transformed this from a difficult situation into something I am cold about in a way I did not expect to still be. Christopher filed a defamation claim against me. A private civil claim, in the county court, against me personally, alleging that my disclosure had contained false statements that damaged his professional reputation and seeking damages of £85,000, £85,000, from a woman on statutory maternity pay, which was running at £172 per week by that point. He knew what he was doing. I want to be clear about that. A defamation claim is expensive to defend even when it is entirely without merit. The legal costs of mounting a full defence through a county court action can run to tens of thousands of pounds before a hearing is reached. If I could not afford to defend it, and on maternity pay, with a 6-week-old and a mortgage and a partner whose income was covering our baseline costs, and nothing beyond them, then I might settle, accept a retraction, undermine the disclosure, make the protected disclosure look like something other than what it was. He was using the legal system as a silencing instrument. I contacted a solicitor named Vivienne. She specialised in employment law and whistleblower cases and had, she told me in our first call, seen this specific tactic twice before. She was 48 years old, spoke at a pace that suggested she had already thought 3 sentences ahead of the one she was currently delivering, and said 2 things at that first meeting that I have thought about often since. The first was, his claim is almost certainly an abuse of process, and we are going to say so. The second was, do not engage with anyone at the firm until I tell you to. She filed at the Employment Tribunal immediately. Automatic unfair dismissal on whistleblowing grounds was not yet applicable as I had not yet been dismissed, but she filed for detriment as a result of a protected disclosure under Section 47B of the Employment Rights Act 1996. She simultaneously filed a response to the County Court defamation claim, arguing that my disclosure was protected by qualified privilege as a matter of law, and that the claim should be struck out as an abuse of process designed to deter whistleblowing. The County Court agreed. The defamation claim was struck out in July. The judge found that Christopher's claim had no reasonable prospect of success, and awarded costs against him personally, not against the company, against him. I want to pause on that sentence because it matters to what follows. Christopher had filed the claim in his personal capacity, which meant that when it failed, the cost order, which totalled £14,200, was his personal liability, not the firm's, his. And a man who has just been personally ordered to pay £14,200 in legal costs, while simultaneously under investigation by the FCA for £273,000 of account irregularities, is a man whose position within a firm begins to shift very quickly. I was dismissed in August, formally, by letter, framed as a restructuring, a reorganisation of the analytics function that had identified my role as duplicated. The letter arrived on the same day that Isla took her first deliberate grip of my finger, which is the kind of juxtaposition that would be heavy-handed in fiction, but was simply accurate. Vivienne added wrongful dismissal and automatic unfair dismissal to the Employment Tribunal claim. The claim now covered detriment, dismissal and victimisation. Total compensation sought £118,400 calculated against my salary, projected career losses, injury to feelings and the aggravated nature of the dismissal following a protected disclosure. Now here is the delayed reveal. Here is the thing I have been building toward. The witness statement that changed the shape of this case arrived in our supplementary bundle 11 days before the tribunal hearing. It was signed, it was dated, it ran to 9 pages. And it was written by Christopher's executive assistant, a woman named Bridget, who had worked alongside him for 4 years and had submitted the statement entirely voluntarily, having been advised by her own solicitor that she had a legal obligation of candour that she intended to meet regardless of the professional consequences. Bridget's statement described, in precise and sequential detail, 3 separate conversations she had either participated in or overheard between Christopher and other senior figures at the firm in the weeks following my disclosure, the first in the week after I filed, in which Christopher had described the situation as manageable and said that a maternal leave absence was a useful window. The second, 2 weeks later, in which he had discussed with a colleague the mechanics of a restructuring that would justify a redundancy without appearing targeted. The third, in the final week of July, in which he had confirmed to the same colleague that the letter was being prepared, and that he expected no further complications from the individual concerned. The individual concerned. That is what I was to Christopher in those conversations, an individual, a complication, a maternal leave window that was useful. Vivienne presented Bridget's statement on the second morning of the hearing. The Employment Tribunal panel, 3 members, chaired by a judge named Lawrence, read it in sequence. Lawrence asked Christopher's solicitor whether his client wished to respond to the specific content of the statement. The solicitor asked for an adjournment. Lawrence gave him 45 minutes. The company settled before the adjournment ended. The settlement was £104,000. No admission of liability in the formal text, but a separate letter, negotiated by Vivienne with a precision I found remarkable, acknowledging that my disclosure had been a protected act made in good faith, that the subsequent treatment had been inconsistent with the company's stated values, and that my professional record was unblemished. Not a legal admission, a written statement signed on company-headed paper, acknowledging what had happened in language clear enough to be understood by anyone reading it. Vivienne called it a form of admission, dressed in different clothes. She was right. The mirror detail I want to return to now is the nursing chair. The 11:43 email, I filed from a nursing chair with a sleeping baby on my shoulder, and for months afterward, that moment carried the quality of something I had done in a state of compromised judgment, sleep-deprived, vulnerable, operating on instinct rather than strategy. What Bridget's statement made clear is that Christopher had been strategic from the moment he received the notification. He had planned, he had discussed. He had described me as a window and a complication, and I, exhausted in the middle of the night, with Isla asleep against me, had simply told the truth. The truth had a longer reach than his plan. £104,000 arrived in my account in November. I'm back at work, at a different firm, in a role that is more senior than the one I left, and pays accordingly. Isla is 1 year old. She is, as I said at the beginning, the most competent person in any room she occupies. This remains true. Bridget left the company 3 months after the hearing. I do not know where she went. She has not been in contact, and I have not reached out, partly because I do not know what the right words are, and partly because I think what she did was so complete in itself that adding my response to it might diminish rather than honour it. A 9-page statement, voluntarily submitted, knowing the professional consequences. That is its own thing. Christopher is no longer with the firm. The FCA investigation is ongoing. That investigation is not mine to narrate. It has its own timeline and its own process, and its outcome will be whatever the evidence requires it to be. I follow it with the specific attention of someone who wants to understand how it ends without needing to be the one who ends it. Here is what I cannot resolve, and what I want to leave with you, the letter that arrived on the day Isla first gripped my finger. The restructuring letter. It was signed by a member of HR, who, as far as I know, had no specific knowledge of Christopher's conversations with his colleague. She signed a document she had been asked to sign by people above her. She is still at the firm. She has never been named in any proceeding. I do not know what she knew, and I do not know whether she asked any questions before she signed. I think about that sometimes, not with anger, with a cooler kind of curiosity, about what it means to sign something you have been told to sign, in a corporate context, when you are not the one who understands the full picture, about how many such signatures exist in institutions, on documents that are part of something the signer cannot entirely see. And what would you have done in her position? What would you have asked before you signed? I genuinely want to know, because I think the answer varies more than people admit, and the variation tells you something important about how these things are allowed to continue.